Hey everyone, welcome to the webinar on e-Stewards and NAID AAA Certification. My name is Bob Johnson. I'm the CEO at iSigma, and my roots in the data destruction industry go back almost 40 years to when I had my own shredding company, and then after that I founded NAID. I think it's been now 28 years ago. So it's been a long road, and thank you for joining us here today. I'm also joined on the call by Prima George, who many of you are already familiar with. Prima, would you like to say a few words?
Sure, thanks, Bob. Hello, everyone. As you know, you received the invite emails from me, registration emails from me. I'm Prima George, the Certification Director for e-Stewards. Thank you, everyone, for making time. So through this webinar, we hope to address any questions you have with regard to being NAID certification ready and any other questions that you are facing in the process, and just to be prepared before the deadline and be certified. So thanks, everyone. We'll get started.
Well, and I guess, taking off from that point, Prima, we'd like everyone to know that we understand this is a process. Some questions they'll come up with, we haven't anticipated and they haven't encountered them yet. It's going to be, so I'm sure I'm speaking for you as well as me, is they're always free to reach out. It's always best to send emails, I think, because we have a written record and we can give a written response that way, and I can share it with Prima and she can share questions to her with me. So please do that. You may note, though, on your console for this webinar, and you're probably used to this already in this day of webinars, but you can submit questions to us during the presentation. So please don't hesitate to do that. And if we can take them, we will. We do have the questions even if we don't get to them, so we can follow up afterward if we don't get to them on the call here. So I'm going to proceed with the first part of this webinar. I can get this to work, and just talk a little bit about who we are and what certification is, kind of the rules. I'm going to go pretty fast. Don't worry about this too much. First of all, you should know that you join iSigma before you get NAID AAA certified, and I think it's important for you to realize that you are joining a 501c6 nonprofit trade organization. That's what this is. That's our corporate structure. So it's a membership organization, and when you become a member, you literally and very legally own a share of the organization, and we are run and managed by our members. We do, as a membership organization, beyond what you've heard of our certification and such, we do advocate on regulations. I would say not a week goes by that I'm not submitting something to some jurisdiction around the world on their data protection regulations or the appointment of a new policymaker, making sure they're familiar with us. We also fight other battles for members, even non-related to data destruction. We've had members where we had to step in where they were being charged sales tax in 2 states on the same thing. That's just one example, but there are dozens of those kind of examples over the years. And we put on conferences and do publications and do other things as well. So it's wrong to think of us just as a certification body, because we're your advocates as well. And we also want you to know that you have a stake and you're part of the leadership of the organization. Now, obviously, what we're here to talk about today, one of the other things we do is offer programs, and NAID AAA certification and PRISM Privacy Plus certification, which is really more for the records management side of our membership. But NAID AAA certification is a program that is offered by the association to its members, and it's just good, I think, to understand the basis of where that comes from. But I also want you to reach out for us if you do see things that we can step in and advocate on behalf of the industry, and that's how we know to do that kind of stuff. So before I get into NAID certification per se, and I'm sure some of you have scratched your heads, and I mean, I know there's a lot of confusion over this. I have spoken at eScrap, well, probably 15 times in the last 20 years. I don't happen to be speaking this year, but one of my first questions is always to the computer recycling and ITAD companies that are in the audience, which is what the audience is. And I asked for a show of hands for any of them who consider themselves to be data processors. You know, I understand that some don't maybe even know what I'm talking about, but I don't get any hands raised when I ask that question, when in reality, they all are. So let me explain that a little bit. And you should just know from a regulatory perspective, these are the three main entities on your screen that are subject to the regulations or that mentioned in the data protection regulations. We don't have time, let alone for this hour, for the whole day, to go into all of the things that are related to data protection regulations. But the individual who shares their information with the bank or with the hospital or with their doctor, the person whose personal information is called the data subject. The data controller is that hospital, is that bank, is that employer, and anyone they're sharing that personal information with. They are largely your B2B clients. And then the data processor are the entities that the regulators, I mean, when they wrote the regulations, they were keenly aware that those data controllers, those banks and hospitals, would be outsourcing things like ITAD, things like record storage, things like managed services, those things, and you are considered under the regulation a data processor. And those are who the regulations apply to. So to those of you who may really question, or you know, not question is the wrong word, but I want you to consider a couple things. 15 years ago, when HIPAA created a whole new class of data controllers, which in HIPAA they call business associates, and of course, data controllers are covered entities. Data processors are the business associates. So anyway, when they created this class, record storage companies, now who are members of iSigma, they did not want to be business associates, data processors, because I mean they pushed back on that. How do we know what's in the boxes we're storing? And the Office for Civil Rights, which is a division of Health and Human Services, came back to the industry saying, you are absolutely data processors, because if you are storing records for organizations, you know that in those records is personal information, and therefore you are a data processor, whether or not you know specifically what's in the box, or whether or not you signed up to be a data processor, you are. Now, further evidence of where the regulations would come down, and that comes from, and many of you may not realize this, but if a landlord if computer equipment or old records are abandoned in an office, and the landlord takes possession of them, vis-a-vis he owns the office or they own the office, they are legally responsible for the protection of that information. They weren't in the data protection business whatsoever, but they were a legacy custodian because those records were abandoned in their care. And what the regulators said is that it's a cost of doing business and an expectation of being a landlord that you know records will occasionally be abandoned in your care, and you have the custodial, you have an obligation to protect that data. I'm just pointing to these two things, probably taking more time than I needed, but to point out that often you don't want to consider yourselves as having this regulatory compliance architecture that you have to evolve with, but just because of the business you're in, where you will know you take in IT equipment that is going to have personal information on it, you are sucked into the regulatory compliance thing just because of the business you're in. And there's nothing really you can do about that, whether you want to think of yourself that way or not. Now, I'm glad to know that most of you do, and most of you embrace that. And you know, we're here to help you along that way. And I guess that's where we feel NAID AAA certification kind of has your back. We're well aware that most of your customers are not aware of what it is they're supposed to be requiring of you. The one thing we know, they are supposed to do that. The laws require that they verify you are doing certain things because you're a data processor under the regulation. So our job in our certification, and what we see our job, is to make sure we're identifying and incorporating those things that would be reasonably or even statutorily required to of a data processor under the regulations. So there's two ways to look at that, both valid. One is that if you're NAID AAA certified, you're pretty darn sure you're compliant with the data protection regulations globally, because that's our job, is to look at them. Furthermore, your client, who is supposed to be doing that due diligence before hiring you, is now protected, because you actually have paid to get that due diligence done for them. So your actions to get certified make them compliant with their obligations to verify you're doing those things. So that's about as preachy as I'm going to get on this. The other stuff is pretty straightforward, but it's the basis for why we do what we do and the basis of why it applies to you. Now let's talk about, again, structure. And this is just for you to know that we're very serious and deliberate about the way we do things around here regarding certification specifications. We have a certification rules committee. All of these bodies, by the way, are made up of your peers. And if you're a member of the organization, you can hold up your hand and serve on these committees as well. Now that requires board approval, but we want volunteer members to be active in these. But these are your peers that are on these committees. Certification Rules Committee develops the specifications for the program. So when there's a change, when there's a modification, when there's a new spec, it came from the Rules Committee. The Certification Review Board is a separate body that responsible for maintaining the integrity of the program. And so non-compliance issues, other things that come up, evaluation of exceptions, we'll talk about that in a minute, is reviewed by the Certification Review Board. The Complaint Resolution Council is simply our internal ethics enforcement body, and they are often called in if there are ever sanctions or penalties that might come from a violation, and they then make recommendations to the board of directors. I will speak a little bit later about the Multi-Location Certification Council, but right from the beginning, pretty much, NAID certification and NAID recognize that corporations that have, really more than 4, because that's where the limit is, 4 or more locations, but obviously companies that have multiple locations, a change to the specifications can affect them differently. So we work with the Multi-Location Certification Council to make sure that those specification changes work for them and modify them for them. And then finally, everything boils down to the elected board of directors. And so we're actually just open nominations for the next board. If you're a member, you would have already received your nomination form to nominate a candidate. It's completely okay to nominate yourself if you want to do that, but that's what that's all about. And so again, pretty serious about how we look at that. If you want to know here who to reach out to regarding questions that you will inevitably have as you move through this, I'm going to say here that we've always had different business models that we've served. That these our members who have gotten certified have had different nuances to the way they do things. I've only found that to be more true in the IT asset disposal and computer recycling space. So there are a number of different business models, maybe which we didn't really fully anticipate as we tried to put the pen to paper. And so those are the kind of things you want to bring to me and talk with me about. So if there's any policies, challenges, questions on that type of stuff, come to me on those types of things. Again, there's my email, and email is best. Shana Van Kilsdonk manages our certification operations here. So if you have a question about, hopefully you would have gotten confirmation that you submitted your application. But if you didn't, or if you have questions about scheduling, anything like that, you can contact Shana regarding kind of the more logistical elements of how the program works. I'll take a breath right now. Prima, have I anything that I've said that you want to comment on per se?
I just want to add that you can send in questions to me as well all of you have my email address already. It's prema@e-stewards.org. While reading your standard, along with the NAID requirements, if you have any specific questions that you either disagree with or need further clarity, do feel free to write.
Thank you. And yeah, and Prema and I, go back and forth and share those things as well, so we're both on the same page. And chances are, if you have a question, there are 10 other people that might have the same question. So regarding NAID certification, frankly, it's two certifications, and they're separate and separate applications. One is for physical media destruction, and it's just what it says. That is for our members who are only physically destroying media, and that could be physically destroying hard drives. So clearly, there are many companies out there that only physically destroy hard drives. They don't do any electronic media erasure, and that's for them. The second type is the second program we have is NAID certification for electronic media erasure. Now, one is more expensive than the other. That is, the electronic media erasure is more expensive. But that's simply because it includes the forensic analysis that goes with us bringing in our sample drives and having them erased, and us removing the drives from your facility and then sending them off to blindly, by the way, they don't know where they're coming from, to a third-party lab to do the forensic testing on those. So the difference in cost is essentially the added forensic analysis that needs to go on. If you do both physical media destruction and electronic media erasure, you will want to get the second one clearly. And it's important to realize that physical media destruction, that endorsement is included within the electronic media erasure, because from the beginning, we've been well aware that if you're doing electronic media erasure, you will have occasion to need to destroy hard drives that you don't want to overwrite, or too old, or have too many defects, or whatever it might be. So, that's a requirement of the electronic media erasure, is that you have the capacity to do and identify the capacity to do the physical media destruction itself. So it is included there. You'll see a note on the screen there that's all our certifications are awarded per location. However, as I mentioned before, there is a multi-location certification for those with over 4 or more locations. And if you fall into that category of having 4 or more locations, we really urge you not even to start with the primary application we have. I think a call to us on how to move forward with that is better. The application is still the same, but certainly the payment structure is different. So you wouldn't want to just send in an application with that payment structure. There's actually advice on the application itself that says if you are in the multi-location program, i.e. you have more than 4 locations, please don't submit your payment here. We'll discuss payment terms with you. So it's just a little bit different there. Not seeing any questions, so I'm going to move on that one, and again, we can revisit. So I'll talk about this later, but while I mentioned that certification is done on a location basis, all locations have to be certified. All locations that are involved in data destruction, I should say. And involvement can mean even accepting of the material, because that is the point at which your obligation, your care and custody of the material start. So the operations that we certify, and it can be a combination of these things, but definitely, usually it's by location, mobile and on-site, and of course that's fully audited, which means both our scheduled audits as well as our unannounced audits. The destruction, it could be a destruction facility where destruction services are performed at a location, right, at a facility, and again, fully audited. There are also recognition for transfer processing stations. Those are fully audited. So to think of a transfer processing station, it would be a location where media is received and stored and processed, sorted, disassembled, whatever, everything happens there except the actual destruction process. So it's a waste station where processing takes place prior to going on to a destruction facility. And again, it's there because of the animal exists, and we know it does. And you might have some facilities that fall into that category. We also have, we also recognize collection-only facilities. So this is a little bit different. So the collection facility process is just a waste station. It's simply a locked warehouse where things are put prior or kept prior to them going anywhere. There's no processing involved, there's nothing. So we do require the transfer processing station, it is a location that we need to certify. So we're going to come in with an auditor, we're going to look at everything, it's going to be subject to unannounced audits, all of those things. The collection only facility, we need to know where they are and you have to report them, but there are no scheduled audits and there are no fees. Now, you'll note I have scheduled audits. The reason we want to know where they are is you have no idea if one of our auditors isn't going to come in and check that collection facility. And it may be a building with completely locked doors, and that's all it is because of the nature of what goes on there. There's no attendant there. There's nothing there to see, but we could do a drive-by or a check on that facility. So, that's why we need to know where they are. It's also important to realize that the transfer processing station and the collection only facility, different animals, you need to identify on the application what destruction facility they belong to, because ultimately the media's got to be destroyed, and if it's got to be destroyed, it's got to be linked back to a destruction facility, and that needs to be identified on the application, and there's a place for that. Talk about audits real quickly, and I'll speed things up a little bit to give Prima a few minutes. Our audits we have scheduled audits. So if you're in the main program, you will have a scheduled audit every 2 years. You reapply every year, and that's to update information and to do all those things. Now, unannounced audits can happen anytime. We've literally had board members who have complained openly at a board meeting that they've had 3 audits in the last 4 months. There is a formula, I want to say algorithm, but I don't want to be so advanced about it. We hire an outside CPA firm to maintain the unannounced audits. There's an algorithm. The longer you go without an unannounced audit, the greater your chances of getting in that queue. But even if you did have an unannounced audit up to a month earlier, doesn't mean you're going to have another unannounced audit at some point. Now, they can range in different ways. So there's an unannounced audit that can look very much like an announced audit or a scheduled audit. And at that point, the auditor would knock on the door, identify themselves, and you agree in the application to allow unannounced audits. More commonly though, or as commonly, unannounced audits take the form of a covert unannounced audit. So the auditor is coming out, and the first thing we instruct them to do on all unannounced audits is to check the security of the facility. So their first stop is not the front door, it's the back door, and it's the dumpster. And they're checking to make sure that the building is secure. In some cases, they'll take photos and you might never know they were there. They will also follow vehicles into the field and take pictures, and you might never know that that covert audit happened. The last bullet there is a directed unannounced audit. And when that happens, it means either that the compliance record of the organization has been a little spotty, and we'll talk about non-compliance in a slide or two. But so we have a point system, much like you do with your DMV, right? We keep points on non-compliance, and if a company gets into the danger zone on that, we will actually direct an unannounced audit to make sure. Also, if we get a credible complaint of non-compliance, and it really could even be a competitor. Now, we get a lot of complaints that aren't credible, so we're able to kind of sort through those. But if there's something that gives us pause, we will direct an auditor to go out and do an unannounced audit simply because there's enough suspicion that we want to verify something. So the fees involved for certification include all of the audits. So I don't generally talk about this much, but I will mention it here, going back to us being a member-owned nonprofit. One of the reasons our certification is so inexpensive is that we don't charge any more than we have to, because it is your colleagues and you guys that are overseeing what it is we charge. So we need to charge what we need to charge to do it, and that's why we bake these things in. But it isn't like we're a for-profit entity or anything like that. All right, so now that I scared you, let's talk about some of the overarching policies here. And hopefully, if I do this, it won't get rid of the screen. I got to see my whole screen here. All right, so presently, NAID certification is only available to those firms who directly provide destruction services. And so, to those of you on this call, know that you can get NAID certified if you're doing destruction. If you're not doing the destruction, presently NAID certification is not something that you can obtain, because it only applies that way. Must be certified, as I mentioned, for all locations where care and custody takes place. You must be certified for all core media types and platforms. So here's an example, and this just came up with one of your colleagues. 90% of your business is refurbishing or doing other ITAD recovery for laptops and servers, and 5% of your business, not even a business you very much promote, is old mobile phones. And so you're certified for the things that you provide on a primary basis. So you get NAID certified for electronic media erasure, and that applies to all the things you destroy. But for those five, we don't require necessarily that you get certified for the mobile phones, because it's not your core business. It's something you do as an aside. The only requirement would be is that you need to let the client know who's using that service that that's not NAID certified. Now, on the other hand, would it be that the recycling of mobile phones was a core business of yours, and so it equaled your ITAD side of your business? It was 50-50, and it's promoted all over your website. Then you need to get certified for that as well. Now, for mobile phones in particular, the endorsement for solid state, either physical destruction or the erasure of solid state drives, could apply to your mobile phones. We don't really differentiate. This mobile phone is based on a solid state drive technology, and so if you're endorsed for solid state device, physical destruction, or erasure, either one of those, it's going to apply to your mobile phones anyway. Hopefully I didn't confuse you going down that rabbit hole. But now, contracting is permitted with contingent provisions. So going back to my last example of 90% of the stuff that you're NAID certified for, you're doing yourself, but you have a portion of it that you have to outsource. That is perfectly permitted, and with, as I said, contingent provisions. So either it can be a NAID certified service provider, in which case you're solid. There's no other thing you got to worry about. Or in the case, you're subcontracting that minor aspect of what you do, you're NAID certified for what you do primarily, but for what you outsource, you are able to you don't have availability of a NAID certified service provider, or they just aren't NAID certified and you want to continue to use them. You're allowed to do that, but you need to notify the client that in that case that that process is non-NAID certified. On this point, and again, another question that I have to tell you, I never came my way until yesterday. It was observed by, I think by an e-Steward, that there had been a recycling company who was offering ITAD services, and they said in their, this is third party, that that NAID's AAA services were provided upon request only. So I don't know who that was, and I asked immediately who's doing that, because that is totally unacceptable from our standards. If you're NAID certified, NAID certification is the default. So to be NAID certified, everything you do must be NAID certified. And the only exception to that would be where the customer is fully transparent to the customer that it's not NAID certified, in fact that they're opting out of NAID certification. And that is critical, and not just for our protection, it's for your protection. If a client opts, going back to what I said at the beginning about what NAID certification is, right? Your client is, your client has a lot of regulatory responsibilities with regard to what you're doing for them. If they want to make a decision that, oh, it's okay not to do that, you need it in writing from them that it's okay not to do that, because you're protecting yourself by getting that overt opt out from them, and that's why you need to have that in writing. But going back to that premise, there's no we do it normally, we do it this way, unless you want our NAID AAA certified services. It's exactly the backwards of that. We always provide NAID certified services unless you will opt out in writing. And if they're opt out in writing, in my, when I write those opt outs, it says, no, it is my decision as a client to be negligent related to my regulatory requirements, so I'm going to opt out of this requirement. Obviously, no client's going to sign that, but that's in a sense what they're doing. All right. I said I was done preaching, but I wasn't. Okay, NAID certified services are the default. I just went over that whole thing. I'm not going to put you through that again. And clients may opt out in writing with reference to the specific provisions. So I got ahead of myself here. I just talked about those two provisions. Prima, I've been taking all the oxygen out of the room here. Is there anything you want to add to some of the things I've mentioned so far? You're probably on mute.
Sorry. In fact, you have addressed 2 of the 4 questions already, so that kind of takes care of that.
Okay. All right, good. And hey, by the way, a lot of these things did come from questions we got from you guys. So the application process, it's all spelled out on the website, but you submit the completed application. We send it off to an auditor as quickly as we can. First of all, we got to make sure the application is complete. Often, about 50% of the time, we need more information, so do that with care. When we do get the completed application, we send it to the auditor. The auditor should reach out to you and set up an initial audit. We do a priority on initial audits, so there shouldn't be much delay in that. And if you are feeling a delay, you need to contact us right away and we'll light a fire. If you need a fire lit, let us know even in advance and we'll light a fire under that auditor to get a hold of you, because you're going to mutually agree when they're going to show up. It's a scheduled audit. The audit report, subsequent to the audit's going to send that report back to iSigma. Auditors do not determine in the field whether someone passes or doesn't. You're going to have conversations with them, we understand, but that's not their job. They're eyes and ears, they're completing a form, they're going to send that form back, and I would just say that 99 out of 100 times, if there is remediation needed, it's simple remediation, and our team here will work with you to make those changes that need to be made. If there's policy language that's missing or needs to be tweaked or anything like that, we'll work with you, and then certification is awarded. So in a perfect world, it's a month-long process. Probably more likely it's a 2-month process without anything said. And what that does is bring us back to a discussion about the deadline, which is in July, I believe, for you guys to qualify. So you wouldn't be successful if you procrastinated. So I'm sure you're not procrastinators. Hopefully you're getting help on this. We'll help you. I mean, we'll hold your hand through the whole process if you need it. So just let us know. But please don't wait until June to send in your thing, or you're going to probably miss the deadline, as probably there will be more of your colleagues doing that as well, and it's going to get kind of crowded. This might be my last thing. I just want to comment on the exception process. We understand that you guys may have come up with a way to meet one of our requirements that suits you better. And maybe it won't work for other people, but because of your situation, you found a way to meet the spirit of the specification, even though meeting our exact specification might not work for you. Well, we have an exception process, and it really amounts no more to than an email with exception request in the subject line sent to me or Shana. We send that on to the certification review board. It might take 2 weeks, 3 weeks, maybe a month at the most, but I can tell you that no one wants to stand in the way. They're all business people trying to make a buck, just like you guys are, and they and they're not begrudging or autocratic in any way. And I've never seen a reasonable exception request be declined. I can be that bold in saying that. So now that I've taken up 90% of the time, Prima, I think we've come into some of the questions you've been getting and things that you wanted to talk about. So here's the first point I know you wanted to make.
Thank you, Bob. So these are the questions that we received ahead of time, some of which Bob has already addressed. The first one is, what is the data security standard to follow until the 1st of July 2022? So if you are not NAID certified already, you will be covered by the data security requirements under Appendix D of the e-Stewards standard. But if you are already NAID certified, Appendix D will not apply to you, and you will follow the NAID requirements. I think that's the next slide, Bob. So that's 1 and 2.
All right, so that was both of them. Good. All right,
yeah.
let's go to the next one. Is
yeah.
this the one we discussed?
This one, the third one, also is something that you addressed some time ago with regard to what is the kind of certificate that would apply to you, physical destruction or electronic media sanitization certificate. So like Bob was saying, depending on the kind of processing you do, you will be qualified to be certified to one or the other. But at the basic level, it would be good to get the physical destruction anyway, physical destruction certificate, because in the event that the electronic process of destruction fails to work for some reason, you must have the physical destruction as a backup. So correct me if I'm wrong, Bob. Do you have anything to add to that?
Well, I would just maybe expand on that a little bit. This goes back to one of our premises, is that if you're offering a service, you need to be certified for it if you're certified for anything. So if you're NAID AAA certified, you need to be certified for everything you're doing. And what that would translate to, I mentioned that electronic media erasure is a little bit more expensive than the physical destruction certification. So someone could say, well, I'll just get the cheaper one and get my NAID certification. Well, if you're doing electronic media erasure, that's not an option. You need to have both because you're doing both. The good news is that the physical destruction is already baked into the electronic media erasure. So it's not like you need to get both certifications, but you would need to get the more expensive. So you can't just get one minor certification and ignore that you're actually doing that other service as well. I think we said the same thing, right?
Yeah. Okay. Thanks, Bob.
All right.
This is Kelly Martinez. We have a couple of questions that kind of relate to what you were just discussing. Is it okay if we ask those now?
Yeah.
So some people are curious about the physical destruction portion when they have electronic media. So, is it okay if you get a hard drive? Can you just press punch, putting a hole in the center of it? Does that count? And what do you do with a CD-ROM or floppy drives? Because those sometimes come in.
Okay, so let's go to the first one first. A NAID AAA certification does not specify the particle size or method of destruction, physical destruction, for electronic equipment, but we do require that the organization be transparent to the public in how they are doing it. So what we're going to look at when we come in is there transparency with how they're doing it. Now, that you might seem like we're abdicating a little bit of the security there. The reality is, and this, NAID certifications overall premise is that the specifications that we develop and address need to be reasonable, and in this case, the client needs to be involved in there. It's been the determination of the Rules Committee that whether it be crushed or whether a punch be driven through the platter that allows it to be inoperable, anything that allows that drive to be inoperable would be suitable destruction. But again, you've got to be transparent in your paperwork and in your client with your contracts that you are being, how you are doing it. So you can't be misleading. Let's put it that way. So yeah, that works fine. A punch, a drill, a crusher, a shredder, anything works as long as you have the physical means for destruction. Now, as far as the other stuff, we're not here to say necessarily, and we're a bit agnostic. If you get an old floppy drive or something like that, you need to destroy it. There's no specification necessarily on how you do it, but you're a data processor, as I mentioned already, and you need to have a way to demonstrate that you can destroy that stuff when you do it. Now, if I'm getting a floppy once every month or 10 a month, I might be burning them in my wastebasket. But I'm going to have a policy that that's how I do it. Which again is another point, is that this stuff has to be reflected in your policies and procedures as well. I know it sounded a little cavalier there. Hopefully that answers the question. Kelly, was there another question?
No, you addressed it. Thank you so much. We appreciate that.
Oh, great. And Prima, I think we're back to you on this one, talking about the tolling operation. This was a two-parter.
Yeah, so we had a question earlier which related to if the customer tells you not to destroy the data, not to sanitize, and they bear the responsibility, would you still be responsible for data destruction? So the answer to that here is yes. We have made some changes through the standard interpretations that was circulated. It's now open for public comment, so I'd recommend that all of you take a look at it, and if you have any questions, please let us know. So this bit is covered there. So basically, if an equipment containing data comes into your care, you will possess the duty of care to destroy it. There is no exception to this rule, and this is applicable even if you have instruction from the customer, unless there is a tolling exception where the customer continues to hold ownership of the equipment and that hasn't been passed on to you. So that would be the only exception. But then again, through this comment period for the standard interpretation, we are hoping that you will tell us if there are any challenges to that only exception or no exception at all. And depending on that, we will decide whether or not we must leave that in the standard post July 1st, which is when Appendix D will be sunset. And also, secondly, the point B, it's the next page. So Bob will also discuss this with the NAID board in terms of the data sanitization being passed on to a certified IDP. So these are two things that we don't have the answer to in its entirety yet. But if you have any suggestions, comments, or experiences to share with regard to this, please write to us. So that's the intent of this one.
And I think I'm going to comment just on B there real quickly, is that kind of goes back to the scenario that I talked about of, outsourcing destruction to a third party. Now, over the years that we've been here, the companies that have come to NAID and to get NAID certified have identified as being in the data destruction business. I mean, that's why they came to us. And so there was really no question that they were doing data destruction because that's the business we're in. We've come to learn that there are a number of ITAD processors who may be taking in materials, but outsourcing all of the data destruction to a third party. Currently, that's not allowed under NAID certification because we don't certify those organizations. And as I said in the beginning, you can only get NAID certification if you're the one doing the destruction yourselves. So to Prima's comment, the board, our board, the iSigma board, is currently deliberating over whether or not they will allow a company to get NAID AAA certified if they have a contractual arrangement with another third party who is NAID certified to do the destruction. Now, we'll know the outcome of that probably within a month, so that may impact some of you.
Okay, thank you, Bob.
Sure.
So the final one is, there was a question with regard to who would be responsible during transit of these equipment. So our recommendation is that the processor will be responsible for data security when something is in transit until it is handed over to the IDP, and then the transfer of risk also will occur, and therefore the IDP will be responsible thereafter. So if you have any questions with regard to that, please let me know.
And you know, you will find, guys, as you get to know me, that I often have a comment for everything, is that this is one of those other things, you know, going back even to one of the earlier slides that Prima had on there, where a client is one thing if the client is going to keep the media after you do for them what you do. But if the client does not intend to keep the media and then they sign off that you have no responsibility to destroy it, and obviously e-Stewards says yes you do, regardless of what they say, but you obviously want that in writing, because any customer that tells you that you can take this media and there's no, you're not responsible for, we don't need you to erase or destroy the information, is, I mean, they're literally asking you to do something illegal, and it needs to be on them. They cannot legally do that, and yet they're saying we're going to make a decision to operate outside of the law, and we want you to abet us in this violation. And so that's why you need to be a little bit more careful on those things. And I applaud e-Stewards for making this decision. But I would also say that you know, hopefully you're not running into too many customers that don't understand that they're violating the law if they say you don't have to destroy the information, and they're willing to risk letting that information go into the world. So, lastly, never thought we'd get there. You know, on behalf of both Prima and I'm sure I speak for Jim as well, you know, thank you so much for the patience to go through this. It's never fun to be, to look at the new things to do. Being in business is a challenge in and of itself, and the last thing we want to do is make things more difficult for you. And I mean, more importantly, we'll just reiterate again that never hesitate to come to us with questions that you have, and that includes bringing questions related to an exception. If you found a better way to do it and it meets the spirit of what we're asking, you know, we can work that into the profile. Prima, any closing remarks on your end?
Bob, I think there is another question with regard to the lead time. The request of NAID certification, how long it will take.
Okay, well, you know, most of how long it will take is up to you, because our clock doesn't start ticking until we get a completed application in. So if we get a completed application, probably within, you know, 5 business days, we will send that to the auditor, who will then contact you again, hopefully. And as I mentioned, we put a high priority on initial audits. So it comes to the auditor flagged as an initial audit, which they have a priority of reaching out and scheduling an audit. So, we will just reiterate that with auditors through this process, but it could take another 5 to 10 days for an auditor to set up a meeting. And of course, if you decide you can't meet with them for 2 months, then it's going to be 2 months. If you can meet with them the following week and they're available, then it's the next week. So again, there are so many things contingent upon your availability and the auditor's availability. In a best case scenario, it's probably 1 month. With a little prodding, more practical, it's probably 6 weeks. And if people are dragging their feet, submitting incomplete applications, putting the auditor off, those types of things, it can extend. For those types of things, that could be extended much longer. So, you know, I would like to see you giving yourselves 2 months to get it done, which means we would need the completed application 2 months ahead of time. But if you can get us to 3 or 4 or 5 months ahead of time, that's even better. So the sooner you can do it, the better. I have not mentioned, and you know, you're all successful business people, so you know, you can roll your eyes if you want on this. But once you're NAID certified and you have this in your quiver, you know, it's our feeling that you can make a lot more hay with it. So it's our job to make sure that this is an ROI on your certification, and we do whatever we can to do that. If we have videos related to that, we have other things related to that. We even have a very new tool that I don't have time to show you right now, where your customer can monitor your ongoing compliance under NAID certification, you know, independent of you. I mean, they literally can go online and get compliance reports directly and automatically. So I'll show that. So I'll share that with you guys in the near future. It's up and running and working very effectively. So again, you know, I'm trying to give you a reason not to put it off. That means if you can get it, the sooner you can get it, the sooner you can start to use it to make sales. Whether you think you do or not, I'm telling you, you're going to increase your sales if you're using our tools to do this. So that's it on my end, Prima. How about you?
I think we have 3 more questions. We still have about 9 minutes, so I think we'll give that a shot.
Oh, no, I'm fine with that.
Yeah. So the question is, if a client is told under a lawsuit and is under a lawsuit and they want the ITAD to hold their hard drives for future use at the court or legal review. So Eugene says they used to label them as legal hold, and this was years ago.
Yeah.
So Eugene,
no. Yeah, that's the customer opting out completely, right? And of course, appropriately, the customer could get in a lot of trouble if they didn't do the it's called legal preservation, right? There's a usually preservation motion. You're talking to a lawyer, so so yeah, they've got to do that, and obviously it's perfectly within, you know, it's appropriate so long as you've got the written request from the client that they have. So
there's documented proof of a legal order that you have to abide by, right. And it is coming directly from the client, like any other instruction that Bob just addressed some time ago. So, and still the duty of care will continue to be on the ITAD processor, and all other requirements will be applicable. So I think that's okay, so next question is, who are the auditors? My question is, can our current auditors audit for NAID? Tracy Phillips' question.
Yeah, no, we have a well, we are, you know, continually adding auditors as, you know, as things. There is a small amount of turnover in our auditors. We have auditors globally. I think we're now at about 21 or 22 auditors globally. Most of them are in North America, where our auditors are. So currently we require that they have they are certified security professional by As Is International. As Is International is the largest security association in the world, and they have an accreditation. It's a CCP, so I must have it off some. But we require that CCP accreditation of all of our auditors, but they're independent contractors and they hold that specification. We are talking currently about recruiting other auditors that might have other specialties that are more inclined with some of the things that we're auditing, but still, most of what we do boils down to physical processes, and the auditors we have are fine for that. So, I mean, that's it right now. We're not looking to expand auditors, but we are very proud of the fact that we use our own auditors and we assign auditors, and that you know, that our members don't pick their auditor.
Okay, thank you, Bob. So this is the last question, I think. The question is, how do you determine how many days it takes per site for audit? And also following with, do you have to be trained for NAID requirements before you certify?
Yeah, there is in the specifications, there is a requirement that you demonstrate that employees have been trained against their regulatory responsibilities, because every employee has for instance, every one of your employees needs to be trained and attest to the fact that they understand they have a legal responsibility to inform management if there's been any data breach or even a risk of a data breach. So that's a requirement. If the employee doesn't have that requirement, then they can't tell management, and management can't fulfill their legal requirement to notify the client, because again, there's a legal requirement to do that. So we do require that employees are trained regarding their breach notification and other regulatory responsibilities, as well as their NAID certification specifications. So we have a canned program that we offer that members can buy. It's a one-time fee, I think of $70 or something. It's an internet thing, and all employees can be trained on it. It's not $79 per head. It's very inexpensive, obviously. But that's not. I mean, you know, hypothetically, the policies and procedures you have internally are going to reflect all of those requirements anyway. And so if you have any kind of internal training that you're using to train employees on that, you can use that as evidence that those employees have been trained. So yes, they are required to be trained, and you've got to demonstrate it either by using our program that we provide inexpensively, or by your own internal training against your policies and procedures, which hypothetically anyway would contain all of this information also. Was there another part of that question?
The audit time, Bob. How do you determine time per site?
The question belies people's experience with ISO and other things, and you take this for what you want, but because a typical NAID on-site audit for electronic media erasure is probably less than 6 hours, because they're going to review the policies and procedures to make sure the language is there. This is something all the employees have been. They're going to background screen. They're going to do those things. They're going to check access control. They're going to do all the things they need to do. They're going to watch the drives they bring in be overwritten. And I'm using that example because that's the longest one. And then they're going to pull drives from your inventory and leave. So if the applicant is ready to show what the auditor needs to see when they arrive, which we certainly hope they are, the average audit is probably 4 hours or less.
Okay, thank you. So that's all the questions there are, and I think we can conclude ahead of time and give those 3 minutes back. So if you still have questions, and if you face any challenges down the road to your certification, please feel free. Bob and I and Jim work very closely. We are in touch almost on an everyday basis to ensure that redundancies are removed, made simple, and we can answer your questions and be available anytime. So feel free to write to us, to both of us, and we will get your answers in.
Thanks again, everyone.
Thanks again. Have a good day. Thank you, Kelly. Thank you, Sarah. Thanks, Angelo.